Welcome to J is for Justice podcast. If live breaking news and following true crime is your thing, then please consider subscribing to my channel. And if you like what you see in my videos, please consider giving them a thumbs up. Hey everyone, welcome to J is for Justice. My name is Jay and I am your host today. Thank you for joining me. We are going to be joined in a few minutes by Mr. Dimitri at DShack Law. He is going to be answering my questions about some of the Delphi filings. So if you have any questions, please feel free to bring them to chat. I'm sure everybody's just now joining. So we'll give everybody a few minutes to get up in here. I see Robin and Shell are here to moderate. Thank you so much, you guys. Good to see you. We are on StreamYard today, so I'll be able to pin your comments. What's up, Miss Kendi in the house? I'm just waiting for Dimitri to join us. Let me get the things up on the screen. Dimitri's awesome. I asked him, I texted him and asked if he could go over this. He's like, sure, let's do it now. I was like, oh my gosh. Okay. Everybody will love it. Love it, love it, love it. So the kind of things that I'm wondering about are, from a criminal defense attorney's point of view, is just with this being sealed like it has been for the past 6 years. Are they allowed to, how did they get away with, presenting this information in a case that's sealed and has been sealed? I don't understand that. There's just a lot of questions that I have. I have to email him the link. Hold on one sec. So if you guys have questions, man, put them in chat because he's willing to answer from a criminal defense attorney standpoint. Thank you, Shell, for sharing that out to everybody. If you are just joining, we are going to get criminal defense attorney DShack Law in here in just a few moments, as soon as I send him this link. Let's get Mr. Dimitri invited on in here. Hey, Miss Nightbot. Nice to see you. All right. All right. Good to go. Good to go. So hopefully you guys have some good questions ready. I know this case keeps rearing its ugly head. And it's so much, guys. It's so much. From a human point of view, I hope you guys are all getting your notifications. I hope that's improved. It is scary, Allie, but what I want to know is, is it real? Because Robin shared in a video with me of someone who is very well rehearsed in Odinism, and I'd love to have him on as well. I'm going to work on that. But he's saying he knows Odinism, and the things that were done in this case are not Odinism. It's somebody who wanted to or who thinks they know Odinism is basically what he was saying. Like maybe someone who watched a show, maybe someone who, I don't know. And Mr. Dimitri has joined us. Let's get, before we bring him on, I'm going to get a poll going. So you guys, I want to know what you think. Now this poll I'm curious if you still think Richard Allen is involved, or do you think that other people are involved altogether? So that's the question for you. And let's go ahead and bring Mr. Dimitri in. Hello, sir.
Hi, how are you? Nice seeing
Hey,
you again.
nice seeing you as well. Thanks for joining at such short notice.
Absolutely, anytime,
I
anytime.
really, really appreciate it because I have a lot of questions. So we've been following this case for about 6.5 years now. And this latest filing that I sent you is for a Franks hearing. So that's my first question. What the heck is a Franks hearing?
So, whenever in a criminal case there's a search warrant, right? So let's work our way back from the beginning, right? The Constitution has something called the Fourth Amendment. The Fourth Amendment basically says, among other things, that the government can't look through your stuff unless they get a warrant, and that warrant is based on probable cause. Now, over the years, obviously, right, the courts have recognized that's not very practical because if government agents, police officers, whoever see crimes taking place, they don't always have time to go run and get a warrant from a judge, right? And so there have been a ton of exceptions over the years that the courts have developed that have effectively swallowed that warrant exception. And you've heard a million of them, right? Plain view and stop and frisk and search incident to arrest and a million others. And so, if and when none of those apply and the government has to get a search warrant, then they have to go before a judge and attest under oath that they need the search warrant for some reason. And when they do that, they have to submit paperwork, typically affidavits, right, in which they detail the reasons why a warrant is being sought. And then, as the case progresses, if that warrant is then issued, the defense has the right to challenge it, right? Because if they challenge it and the challenge turns out to have merit, then whatever was obtained as a result of the search that was authorized by that warrant may be thrown out. And that way, the criminal case obviously becomes a lot weaker depending on what that evidence could be.
Okay. Well, thanks for explaining that. Because a lot of these things, we see them and we come across them. We're like, okay, what is that? We just recently covered a case that did a Miller hearing. So that was something new for me then as well. So let's start here. Have you ever submitted anything like this in a criminal case with a table of contents and everything that we see here?
Oh, yeah. Well, this kind of stuff is submitted in cases all the time, criminal and civil. Whenever you submit memoranda, you typically have to do it in this format, considering the case, right? If it's a complex case, you have to run through all the facts and the backgrounds of the case law. This is a long one. It's not even terribly that complicated, it's just long.
Mm-hmm.
Depending on where you are in the country, you have to do real detailed memoranda.
Okay, so if you're working with a case, because this case has been sealed, we've never heard anything about the crime scene. We had no idea what the crime scene looked like. And then they filed this publicly. How does that work in a sealed case?
Well, there are certain elements of criminal cases, very many criminal cases, that have sealed documents, right? That doesn't mean everything is sealed. But there are a variety of reasons why a system would seal the documents. Sometimes there are privacy concerns. Sometimes you take into account the interest of victims of crimes, things of that nature. But a sealed case doesn't necessarily mean that all of it is sealed all at once. And then lawyers and other folks can go through the process of having those documents unsealed sometimes.
It just threw me through a loop because the judge has unsealed, like you just said, some of the documents along the way. And we've seen a little bit here and there. But this, seems to lay out everything that they wanted to keep sealed as far as like the girls' bodies, um, descriptive as far as, blood spatter, things like that. And they're they're trying to say that this has to do with Odinism, and I don't know if you're familiar with Odinism, but I've personally never heard of it. It's some kind of Viking based religion, like a pagan religion. And they're describing all of these sticks. Now, these girls were found in a forest, so there's sticks everywhere. But they're talking about specific placement and saying that this was some kind of a ritual. So, in order for the defense to put something like this, if they're saying it wasn't my client, right? Like, say this Richard Allen is your client, and you're defending him, and you found out about these people that have this Odinism connection. You found Facebook posts. It's very similar to what is being described in these documents. Can the defense embellish? And I don't know if embellish is a good word, Dimitri, but like, for example, the sticks, they could have just been sticks that fell off trees and just landed in random spots, and they're pulling these symbolisms into it. Can you tell us a little bit from a defense attorney's standpoint what the objective of this memorandum would be? I guess.
That's a great question. That's a great question. Look,
thank you.
Lawyers are permitted to make creative arguments, right? Lawyers must make arguments in good faith. Lawyers can't pull stuff out of the sky and bring those things into court. Now, it depends on when you're making the argument. If you're making the argument at this stage, meaning the pre-trial phase of the case, you do so in memoranda such as this, and you do so before a judge. Okay? Now, why does that matter? Because a judge obviously isn't a juror. So a judge is, in theory, right, an educated legal scholar who can parse out these details. A judge is not what they call a fact finder in the case. Judges don't determine guilt, jurors do. So, if you're trying to introduce stuff like this, sometimes you're better off doing it in a motion of this nature, because you may not be able to do it at the trial, right? At the trial, in order to introduce evidence before a jury, oftentimes you have to put forth some what they call offers of proof. You have to show that what you're introducing has some basis in the case.
Okay.
You can't pull stuff out of the sky. So if you're making arguments that are so creative that they seem implausible, let's say, or difficult to believe, sometimes you want to introduce it at this stage of the case because you can get it in easier. And now you have that in the record, A, and you give the prosecution some idea of what your defense will be. Because if you keep this to yourself, then at trial, you may be faced with an issue where the judge will say you don't have a basis to bring this in. Now, the judge could say that now, right, and get rid of this motion and strike everything that's in there. But that's different than having that done at a trial before a jury, right? Because if you have a theory of defense that you're relying on, you don't want to
have that thrown out the window on the spot, right?
Right. And so maybe that's one consideration. Making creative legal arguments is always a risk, but as long as lawyers do them in good faith, lawyers do them in everywhere in the country all day, right? You see some of the stuff that's going on with Trump and his lawyers now, right? The argument is that they stretched that idea too far. That happens rarely. So when you have arguments such as this one, it's possible that is why it's in the case now.
Okay. So basically what you're saying, if I'm understanding correctly, is basically they're laying out their defense for their client in this memorandum.
Well, they're certainly laying out their defense, right? The question is whether or not they should have held on to their defense, right? Mm-hmm. They assess the risks of this motion getting granted. Generally speaking, the chances of these suppression motions being granted is rare. And so some lawyers would say, well, you want to hold on to it and then hit the prosecution with this at a trial because they won't see it coming. Here, they know what you're going to do now. But right. Maybe they weigh that risk against the possibility of being precluded from introducing this at the trial. And so they know this case and I don't. And I'm sure that they weighed those risks and they made this decision in a very calculated way.
Right. So that brings me to my next question. So in this memorandum, they do name several people as being the culprits here. Is that something that, you would shy away from unless you really believed it as a defense lawyer?
Well, what you believe as a defense lawyer is meaningless, right? What you're permitted to do as a defense lawyer is make arguments that are sound in fact. And all lawyers go through this analysis every day of their careers, right? Every lawyer that makes arguments in court must make sure that those arguments are being made in good faith, right? It's okay, some lawyers would say, to operate in the gray, but you never want to step over that line. And I assume that if these lawyers made these arguments, they have some basis of fact, even though these arguments seem, uh, let's say, unique, right? Perhaps they have some arguments and some ideas as to why they're making these arguments.
Mhm.
Most lawyers should, and these would be no different.
Yeah, I read through them and I just feel like they're putting these people out there and they're also backing it up with depositions they're mentioning of these suspects they're naming. They were questioned, and then they're also using some of, personal things and things they found in their research, to kind of put them in there. But they're also not only using other suspects, they've also talked about, elections and the police being corrupt. There's a lot of angles thrown in here, so to speak. But the biggest one is this Odinism. And I think everybody is just thrown because we've never heard of it. So we're reading all of this and they're backing it up with depositions. Like, this guy was interviewed and he said this, this, and this. And then they kind of fold it into this case. But you're just saying that's their job, is to poke holes in whatever the prosecution is presenting, right?
Their job is to create reasonable doubt, right? Reasonable doubt is, rather, beyond a reasonable doubt is the highest standard we have in our law, right? To create reasonable doubt, some lawyers would say doesn't take much, but it does take something. And you can't just make pie in the sky arguments and hope that that will be enough.
Mhm.
So surely if they're going to make unique arguments, they have the evidence to do it, you know?
Yeah, 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 yeah. So let me ask you, he's claiming mistreatment in jail. The suspect that has been arrested. Richard Allen he's withered away to nothing. And he's saying that the guards, and I want to get your take on this because it sounds so outlandish, but you just never know in this world, So he says that the guards are against him and that they're wearing patches that say something about Odinism. In Odinism we trust. Does that sound like something like legally that the prison could even do?
Oh, I don't know. I mean, I'm not an expert at prison uniform coding, but what I will say is you better have an idea of what you're trying to get done when it comes to things like this. When inmates allege mistreatment, right? There
Mhm.
are really one or two reasons why you're doing it. Number one, it's possible that you're doing it because you're trying to suppress some evidence, assuming you were uh, saying something in the context of the jail system that you once suppressed, something of that nature. It's possible you could be building a civil rights case, right? For down the line, you could sue prisons and prison officials for mistreatment. Um, but that's really it. In terms of making arguments like that, look, it's possible that that's true. I don't know enough about Odinism or about what inmates, what corrections officers wear on their uniforms.
Mhm.
Um, but again, you would hope that lawyers make sound arguments because
Mhm.
that's what our whole system is built on, really.
Right. So if they say that these patches are being worn, they should have some kind of a video or photo from the correctional facility to back that up.
They could also submit affidavits from their client. There's a whole bunch of issues that go in,
Mm.
a whole bunch of issues that go in if you do that, because there are privilege issues there. So look, it's really dependent on what they're trying to do here, big picture. They probably have an idea, right?
Mhm. Oh, I'm sure. So let me give you one more scenario. I know
Sure.
you have limited time
Not
today.
at all. Go ahead.
You're good. Okay. So before all of this, I think it was back in April. Don't quote me on the date, but the suspect, Richard Allen, talked to his wife, allegedly, is what we heard on the phone, and that he confessed several times to committing the murders. And could this be his lawyers like playing cleanup? Did he maybe have if he had a weak moment and he confessed on the prison phone? What would you do in that situation if your client that you're trying to defend in this case all of a sudden makes a phone call to his wife and says, I did it?
You tell every client that is incarcerated pending a trial that whatever you do in that court system is monitored, particularly the phone calls. If the prison system is smart, they put big signs on top of the phone saying you are being recorded. And there's a reason they do that, right? Because, again, going back to the Fourth Amendment, right, under a case called Katz, which people, I guess, don't really care to know, but there's a case that discusses what an expectation of privacy is, right? And that case determined, and the cases that followed it determined, that in prison, your privacy rights are heavily, heavily diminished. So the government can track your phone calls, right? And in many cases that I've seen, the prosecution will get those phone calls and they will introduce it as evidence. And there are very few pieces of evidence that are destructive in a criminal case that defense lawyers are terrified of, things like video and DNA, and confessions are up there as well. And this is effectively a confession. It's very hard to get a statement like that thrown out unless you're able to show something unique.
So maybe that's the drive for the uniqueness of this memorandum, right?
Well, but the uniqueness would have to come out of why the phone call shouldn't come in. I don't know that this accomplishes that. Again,
yeah, you haven't read it.
Yeah, I haven't read through the 136
Well,
page.
they do claim that he's being mistreated and that he was coerced into making that call by the guards.
Well, okay, so that's something they could possibly rely on. Again, it would be an uphill battle.
Yeah, so how would you feel about that if that was your client? Would you just be like, oh no?
Oh, hey, in every case I have, there's bad evidence.
Yeah.
This is some pieces of evidence are worse than others when they're bad. But you deal with it. I mean, you deal with it in the best way that you can.
So Michael in chat says they're only doing cleanup. They don't have a leg to stand on. They're playing all their cards on the table right now and trying to pull an ace out of the hat, and they don't have one. See, some people are like, I don't think this guy did it anymore. And then it's the other end of the spectrum where it's like, this is smoke and mirrors. So that was why I was so anxious to hear your opinion, because I mean, you probably don't like hearing that term smoke and mirrors and what you do, but that's the comments that I'm hearing. So do you want to kind of talk about that, like the misconception of smoke and mirrors when defending a client?
Yeah, I mean, look, it really arises out of that same set of ideals, right? As a lawyer, you are required to zealously represent your client, right? The law not only permits it, encourages it, right? And obviously, the law will put in place certain measures to prevent you from doing improper things. There are rules of ethics. There are obviously criminal statutes, right, to keep you from fabricating evidence and perjuring yourself and inducing perjury and things of that nature. But really, anything short of those things, you are obligated to make arguments on behalf of your client, no matter how strange they are, as long as you're making ethically sound arguments. And so this whole smoke and mirrors thing is nice when you view it from a layperson perspective. And that makes sense. I mean, when I'm not involved in a case and I'm watching a documentary with my wife, right, and it's a legal documentary and things come up, I also, tend to smirk here and there.
Mm-hmm.
As a lawyer, your role changes. It's not the same. Just like, people have different roles in their jobs and in their lives. And so it's very different. Their lawyers aren't looking at it the same way you and I are looking at it, and they shouldn't. That's the whole point.
Mm-hmm. That's why I love getting your perspective, because I definitely don't think like a lawyer, and a lot of the listeners don't, So
No,
it's great.
no, and it would be strange if they did, right? Unless you're intimately involved in this system, you don't really know how to you know juggle all those balls at once.
Right, right. That's why we're so happy that you are a resource here. And I know a few people have been checking out your channel. So we've got that scrolling in the chat and also in the description of the video. So make sure that you check out Dimitri's channel. I see you're doing some political law stuff over there.
Yeah, whatever interests people, that seems to interest people. And I'm not a
For
political
sure.
person. I'm not a political person at all. But when politics and the law cross, I can always talk about the law involved.
Yeah, for sure. For sure. And that's huge right now.
Yeah,
So let's see if we've got any other.
go ahead.
Oh, we've got Robin. She said, I think I missed it. Can the defense get into trouble for releasing sealed details regarding the crime scene if it's been sealed previously?
That's a great question. It depends. The answer is it depends. Like most things in my job. If there's a ceiling in place, then the ceiling is usually pursuant to a court order, and that court order has specific directives in it. So if they're permitted to do so, then they would presumably do it within the confines of what they're allowed to release. Sometimes you have cases that are sealed en masse, that are sealed top to bottom. And if that's the case, obviously nobody can release anything. And if lawyers violate court rules, of course they can get in trouble, and those troubles range in severity. So that's the answer.
So Emily Elizabeth says they don't have half the evidence they need because Ellie never sent it over. So that's pertaining to some of these suspects they name. They did question a couple of them, and there are some connections, like the one guy, his son dated one of the victims. I mean, they were like 12, 13. So I don't know if they dated. They probably talked on the phone or whatever. But there's connections, So they're definitely playing on that and playing on this Odinism in this guy's Facebook and his similarity in looks to the suspect sketch. But so they're saying there's all this evidence we haven't received. And they're saying that there's specific things, and this is one thing. They said that there's a F written on the tree where the girls were found, written in one of the girls' blood. And it's an F symbol. So my question for you, Dimitri, is can the defense say there was blood on the tree if there wasn't?
Can the defense say if there? The answer to your question point blank is no,
Okay.
in the way that you phrase it. But can they make arguments depending on what the other pieces of evidence would be? Possibly. Can the defense? Your question broken down and pulled back is, can they say that something existed when it didn't? No. The answer is no to that question. But that's a very narrow way of looking at it. Most lawyers can usually operate under facts that are a lot more detailed than that,
I just want to know, like, basically, if they say there's blood on the tree written in an F, is it safe to assume that there was blood on the tree, or is that going and assuming too much?
No, if again, if you can make a good faith argument, right? If there's blood somewhere and you can make an argument as to how long that blood has been there, why it's there, where it came from, if you can make all those arguments in good faith, then you're allowed to do it. You can't lie, you can't make stuff up, and you can't draw connections that are blatantly not there. But again, right, in this line of work, there's a whole lot of gray between those two extremes.
So we can take that with a grain of salt.
Yeah, I mean, you can take all arguments with a grain of salt, and then until a jury comes back and lets you know what they think.
Will the prosecutors respond to this motion?
They should. Absolutely. Okay. Absolutely. Okay.
So hopefully we can read that, because then that will give us more context into what evidence they really have.
Absolutely. And let's keep another thing in mind, right? And this is a bit of a broader discussion, but it's worth having, right? Mm-hmm. In every criminal case,
Sorry, my dog just knocked stuff over.
that's okay. Mine is sound asleep in my bed.
Oh,
I know
mine's going crazy here.
your pain. Look, in every criminal case and in every case in general, there's something called discovery. Okay, discovery is the phase of the case in which the sides have to turn over evidence to one another. Let's say, right now, for many years, for many decades, the rules in many places were such that prosecutors would have to turn over virtually nothing, right? Then, as the years passed, that stuff has changed. And now there are some states, like New York, for example, that have very liberal discovery rules where prosecutors will turn over really their whole file to defense lawyers within a very short period of time. And so in this discovery phase, all of this evidence must be turned over. Now, depending on what state you're in, you may have less restrictive discovery rules. And so defense lawyers have to work harder to get evidence. Prosecutors will say that this evidence isn't relevant, right? This evidence isn't something we're preparing to introduce a trial, doesn't support a claim or defense, things of that nature. And the defense lawyer's job will be to figure out a way to draw enough relevance that they can now be entitled to that evidence. Because remember, in many cases, prosecutors around the country have resources that are a lot more broad than defense lawyers, right? You're operating in a system where public defenders kind of rule the day in terms of the majority of cases. Mm-hmm. And so it's important to have a system in place where prosecutors turn over that evidence, because defense lawyers and defendants oftentimes don't have the resources or the energy to be able to get that information on their own.
It just doesn't seem fair after 6 years that they're still waiting for certain evidence.
Yeah, and that may be a legal move, right? Prosecutors may have looked at the rules governing discovery and said, this is what we can turn over, this is what we can't. There's also something called the Brady rule. If somebody's interested in looking that up, it's a rule coming out of a Supreme Court case called Brady versus Maryland that designates that prosecutors have to turn over exculpatory evidence that tends to provide to prove innocence, rather. So all of these come into play, right? But unless you have a hard line rule, as New York kind of has these days, it's always possible prosecutors can argue out of what they have to turn over and why they haven't turned something over, and so on and so forth.
As far as exculpatory evidence, as a defense lawyer, if you believe that the prosecution holds exculpatory evidence that would exonerate your client, right? How would you handle it? This is a little off topic. This doesn't have to do with this case, but how do you handle that as a defense lawyer? If you know and they're not handing it over or whatnot, what do you do with that? Do you go to trial?
Well, here's what you do. You have to separate it into two separate scenarios. In one scenario, you have documentation, you have some proof that the prosecution is withholding. If you have that, that may make your life a little easier, right? You can come into court and say, Judge, I have a witness that says X, Y, and Z. They said this to the prosecutor 2 years ago, and I want that statement, right? And that's one thing. But oftentimes, more often than not, really, unfortunately, or fortunately, depending on the prosecutor, you're really dependent on the prosecutor's good nature. Now, if prosecutors don't turn something over, and particularly in a serious case and it's important material, and prosecutors are determined to have willfully excluded that evidence from discovery, from disclosure, they can get in big trouble, right? So prosecutors don't like doing that because they expose themselves in a big way, especially these days, because so much of evidence is technologically based and you can trace things, and they have cell phones and things of that nature. So at the end of the day, you're still really relying on the prosecutor. And if the prosecutor doesn't turn over evidence, you make arguments in court, right? And a judge will make a decision. And then you decide whether or not to go to trial based on that. Now, what you do when you make those arguments is what lawyers call, you preserve the record for appeal, so that if you go to trial and you lose, you can then appeal it and say, well, I tried to get this evidence, it wasn't turned over, I know it exists, and that's why I lost, and if I'm reversed, then I can introduce this evidence, so on and so forth. So do you go to trial is a complex question. That's one of the considerations that goes into it, right? What evidence do I have? What evidence don't I have? And what impact that'll have?
I guess, if there's evidence out there that can exonerate you from a crime, why would you want to sit in jail a day longer than you'd have to? So let's say a witness had like a witness's testimony could get, prove that you didn't do it. Would you, and then okay, so this is what I'm talking about, the Idaho case. I know you don't know much about it, but what happened was they had a probable cause, right? And then they were going to have an arraignment. And then the defendant started saying, this witness has exculpatory evidence that could exonerate me. And what happened was they went and did a grand jury indictment instead of doing the prelim. Or the prelim, not the arraignment. I'm saying that wrong, but
Okay.
you knew what I was saying.
That
So
makes more sense.
instead of a prelim, they did the grand jury, but they were originally going to do a prelim. And then it seems like he started talking about this witness having exculpatory evidence. And then they went behind the scenes, indicted him by a grand jury, but we still haven't seen this exculpatory evidence. And the defense or the prosecution says, we've given everything we have. They've said it several times. So what's your take on that?
So when you say we have a witness, so that you mentioned again, as you mentioned, I don't know much about it. You said that the defense said we have a witness. What does that mean? Did they have an affidavit?
So there was 5 people in this home, or actually there were 6 people in the home. 4 were killed, 2 survived. So the 2 surviving roommates are these witnesses. We don't know what they saw because everything's sealed. But the defense is claiming that one of the witnesses has exculpatory evidence, and it's the witness that her statements aren't in the probable cause. Only one surviving roommate's statements, because she saw the perpetrator, are in the probable cause. The other roommate, we don't know if she was sleeping. We don't know if she got up. We don't know what she saw. So I don't know if that was the defense's way of trying to figure out what the girl knows before trial. Like, what did she see? What did she hear? We don't know.
Well, and if you don't get information about that prior to a trial, then what you do as a defense lawyer is you go up in front of the jury. This happens all the time. And you say, ladies and gentlemen of the jury, the prosecution has to prove this case beyond a reasonable doubt. It's their burden, their standard that has to be met. And if they don't meet that standard, because there is something you don't know, like a witness statement or something of that sort, that's on them. And you count that against them in your deliberations. So it's possible you can go that way. And it's possible you can sneak it in the trial if you can do it the right way through other witnesses and so on and so forth.
Okay, so let's take it a step further. So the defense requested the grand jury transcripts.
Yep.
Okay. So they would know if that girl testified in the grand jury proceedings, they would know what she said, correct?
Right.
So if anything came up in that grand jury proceeding that could prove he didn't do it, would they bring that up now and say, hey, we need to have a hearing because my client clearly didn't do this? Does that ever happen?
No, because the decision as to guilt or innocence is for a trial. That's literally why a trial exists.
So you can't bring something in and say, hey, he wasn't there.
You can, no. You can bring in anything you want. Whether or not the case will get dismissed because of it is a different story. Right? Generally speaking, right? When one side says he's guilty and one says he's innocent, there's a trial for that. That's why trials exist. And unless it's a real strong case of innocence, very rarely do judges outright dismiss cases. They have that option. There's a mechanism in the law for that. But that happens very rarely because a judge will then be taking away the decision from the jury, right? These are decisions that are designed for the jury. That's how our system works. And you're going to have to work real hard to get a judge to say that this case is so clear that no reasonable jury can convict, and therefore we have to take it away from the jury. That happens very rarely.
Would that happen in a case where you were accused of a crime and you have like video showing you were somewhere else at the exact time of the crime and couldn't have done it? Or would that still go through the jury process?
So it's good. It's funny that you bring that up. So most states, what you're referring to is an alibi defense. And most states, including New York, have rules in place where if you're a defense lawyer who has an alibi defense, you have to bring that up very early in the case if you're going to use it. Because then a prosecutor could look at it and say, okay, no case, right? So if you're a defense lawyer, when it comes to an alibi defense, right, when you have a defendant being accused of a crime and the defendant says, well, I wasn't even there and I have 5 witnesses to prove it, that's something you introduce really, really early in the case. And if the prosecutor is reasonable, the prosecutor will dismiss, right? So alibi defenses are unique in that way.
So we have an alibi defense that's been put off in the Idaho case. He said he had an alibi early on. First, he said, I can't wait to get brought back to Idaho, extradited to Idaho so I can be exonerated. That didn't happen. Then the defense said he had an alibi. Well, then when they had the date come to where they had to produce the alibi, they asked for an extension. What does that say to you? Well, we're going on 8-9 months.
Well, it may say that they don't have a strong alibi defense. That's what it may say, right? Because if you ever, I mean, think about it, right? If you have, unless you have corruption in the system, which is possible, but it happens rarely, right? And you have a prosecutor that's going to just swing for the fences no matter what, which we really hope doesn't happen in this country, right?
Right.
Then you introduce an alibi defense, and if you have evidence for it, irrefutable evidence, which is also hard to produce, right? Then the prosecutor would dismiss the case. Now, an alibi defense is just an alibi defense. It doesn't mean it's a good defense. You're required to disclose it so the prosecutor can take a look at it and see if it's worth discontinuing, right? But if you have an alibi defense which just says, well, I was at my girlfriend's house that day and my girlfriend is my only witness and she's going to back me up, that's not a very good alibi defense.
Hey, Dimitri, how about this alibi? How does this sit with you? I was driving around. I like to go for late night drives, and I was just driving around.
Okay, well, is there proof of the fact that you were driving?
Yeah, the prosecution said he drove by the house several times where the murders occurred. So he's saying I was driving around, but I wasn't there.
So I was driving around and nothing else doesn't seem like a very good alibi.
I didn't think so.
Right?
I mean, especially for someone who said for, 6 months, I've got an alibi, that will exonerate me from this crime.
A good alibi defense is I was in another state. Here are my plane tickets and here are photos. That's a good alibi defense.
I wasn't even in the same vicinity as this.
That's a good alibi defense. But there's a reason why alibi defenses hold a special place in the law, right? Because they're not a regular defense. They're a defense that is quite literally hit or miss, right? Either the person wasn't there and has really good evidence, or the case goes to trial and he can present that alibi defense to a jury and the jury will decide. Right, but if you're going to try to get a case thrown out because of an alibi defense, then you better be sure that it's a really good alibi defense.
Yeah, not that you were driving around in the neighborhood at 4 a.m. where the 4 kids were killed, right?
Right.
And how do you feel about it as a defense lawyer? Like, if you were defending this person and you've made these kind of filings, saying that, he's got this alibi, and then, I mean, from his lawyer's perspective, can you even try to put yourself in their shoes of what they might be thinking?
Well, but it's one of those things where if you're a defense lawyer, oftentimes, very, very, very often, your only real source of information is your client, right? In the majority of cases, your real source of information is your client, and so you rely on your client. And if your client tells you something, you're obligated really, unless it's so weird, right? You're obligated really to bring it up. What you want to do is, if your client tells you that that the client has an alibi defense, you definitely want to put it out there, and then you can use it later on or not, right? But what you don't want to do is not put it out there and then be precluded 2 years down the line at a trial, and your client's yelling at you saying, I was telling you this, and you didn't even put it out there, and now I'm screwed.
Right. And it's a death penalty case. So she's going to be crossing all her T's and dotting all her I's and putting out everything that he wants her to address, right? As far as
Exactly.
As long as it makes sense, I guess.
Yes.
So she's basically doing her job, and she's doing it right so that there's no issues and no appeals later where he can say, I didn't get effective counsel, or I wanted her to, use this angle and she didn't, type thing.
Yeah. And those cases are really hard to win, right? Very often, rather very rarely, do ineffective assistant motions to vacate succeed, right? Because what you have to show is not only that your lawyer was ineffective or made some mistake, but on top of that, you have to show that had that not happened, the result would have been different, which is impossible to show. I mean, it's virtually impossible. So those emotions succeed very rarely anyway. But as a lawyer, you want to do your job because you can be penalized if you're not. And, you always want to keep clients happy. And,
So it sounds to you like the defense is doing everything that, their client is needing.
Look, I may be biased, right? But it is very, very, very rarely that you'll show me something that a defense lawyer does, and I'll say this is flat out wrong. It'll almost never happen because you are required to defend your client to such a strong degree that you have to use everything in your toolbox. Of course, you can't violate the rules. Of course, you have to comply with the rules governing legal ethics. Of course, you have to make sure that you don't break any laws. Of course, obviously, right? But you have to make sure that your primary concern is your client. That's what I do. That's what most lawyers do. They should.
Makes sense. And, I guess that's why everybody's saying she's really doing a good job, defending him. But it seems like a lot of these filings, and I know you don't know the case, but it seems like a lot of it does come from his mind versus something she would put out there. And another question I had about defense filings, is there ever a time where you use your client's verbiage versus your own in a filing?
That's a weird question because you can't, whenever any discussions that you have with your client are privileged, right? So there's a whole bunch of rules governing when you can break that privilege, really. But you have to be careful about quoting your client, right? And you don't really have to do that, right? Because you can make arguments effectively without that.
I don't mean necessarily quoting them, but just some of the filings in this specific case we're following are weird to the point where, like, for example, cameras in the courtroom is a huge thing right now in this case. And the prosecution is saying they don't want cameras, or they're on board with no cameras because of the sensitivity of the information and the witnesses. The defense says we don't want cameras because the cameras we've had so far, it's been a pool camera. They say they're focusing in on the defendant too much. And then someone on Twitter zoomed in on his zipper of his pants and made it look like his fly was down and made fun of him. So the defense actually took a picture of the Twitter post of his fly being down, and in the motion said that the media is focusing on his fly. And it just seemed like such an outlandish thing to put in this court document because you can't control what people do if they zoom in on something after it's taken.
Well, you can if you take cameras out of the courtroom, right? So the argument is not so much about the fly, right? The argument is that in these kinds of questions, we balance the freedom of the press, which we have here, right, against an individual's rights. And you have to find that delicate balance because you can't let something happen in the courtroom that'll prejudice the defendant, right? And an argument that is possible here, judging from what you're telling me, again, I don't have the facts in front of me, is that the defense lawyers may be making an argument and saying, if this guy is caricatured in some way throughout these proceedings, and that infiltrates the jury in some way, that may prejudice him. And the last thing the system wants is to convict somebody not based on the evidence, but based on outside factors. So that is, I think, what the argument is. It's not so much about the fly, which may sound silly to people, but
it does.
But the bigger point is that
this is what's happening.
Our client is being zeroed in on, and that exposes him to prejudice that may be improper, and we want to prevent that.
Thanks for explaining that, because I read it, just as it's written, and I'm like, are they for real? His fly? Like, this is such a weird thing to read in an official court document.
Yeah, and that shouldn't probably be the only argument that you make there about that kind of stuff, but it's a prejudice argument, right? It's a prejudice argument, and the last thing that the criminal justice system wants is to convict the guy on that and then have that motion vacated for whatever, have that conviction vacated for whatever reason, or have that appeal granted for whatever reason, right? You want to make sure that the defendant is protected, right?
Yeah, yeah. And I know we've been going for about 40 minutes now. This will be my final question.
Okay, go ahead.
And I would love to have you on again.
Anytime.
I appreciate that. So one thing, back to the Idaho case, I know we started with Delphi, but this Idaho thing is just crazy too. One of the victim's fathers has stressed it, and he knows a lot more than we do, right? And he has stressed a concern about commonalities, that's the word he used, between the defense and the prosecution. As a lawyer, what do you have any idea what that could mean besides they're both paid by the state?
That's a tough one. Commonalities between the defense and the prosecution is
Mhm.
the idea that they're all working for the same side.
Yeah, he kept
I don't
saying,
know.
yeah, I mean, that's the only thing I could gather from it too. I just wondered if there was something I was missing. He just said there was concerns about the commonalities between the two, and if it wasn't addressed, that he was going to address it publicly. So,
You can't imagine how many times I get calls from clients. I don't know if clients say this about me to other people, but I hope they don't. I get calls from clients saying, I want to switch my lawyer because I think my lawyer is in cahoots with the prosecution. What do you want me to say? Right? Look, it's something that people say all the time. And I will tell you what I tell those people. I will say, if a lawyer does that, they can lose their license. They can possibly go to jail, right? They can be in a whole lot of trouble if that happens. So is it possible? Yes. But I'd be really reluctant in making those arguments, right? Because that would be such a strong violation of the way our system is supposed to work. It's possible. Look, there have been prosecutors that have been put in jail for doing illegal things. There have been defense lawyers that have been put in jail for fabricating evidence and inducing perjured testimony and all these other things. These things happen. They absolutely do. And not once or twice. They've happened several times throughout history. But you really got to you got to really be careful before making those arguments, particularly in very serious cases like this, because the lawyers that handle these kinds of cases are typically experienced litigators that have been, in the well of a courtroom for years and decades.
yeah, that was going to be my next point to you, Dimitri, was that not only is the county prosecutor prosecuting this case, but they brought in 2 state prosecutors to assist.
Yeah, so that happens sometimes in places not, in New York City, for example, you don't really have that unless there's a conflict because every prosecutor's office has 500 prosecutors. So unless there's a conflict where you have to bring in somebody from the outside because you don't want the perception of some impropriety,
like a small town type thing.
But in some cases they have private defense lawyers and private lawyers prosecuting cases, right? Because the systems are different.
Right.
But that'll happen just if there are resource restrictions depending on where you are.
Well, I kind of like hearing that because that makes me feel like the defense has backed themselves up to avoid any kind of, small town, good old boy system coming into play, right?
Yeah, look, I'm not a conspiracy theory guy, but I understand that these things may exist, in various places. I'm not denying that they exist. All I'm saying is that just make sure you have your ducks in a row before making that kind of argument. That's all.
Right. And you think it would be very rare that they would make those kind of arguments without backup?
Well, I don't know. I don't know the backup. I know that generally speaking, in my experience, these things don't happen.
Well, thank you for that. And thank you for your time today. I love picking your brain.
I don't know what you'll find in there, but
I don't know. We get some answers sometimes, so it works.
No problem.
I want to thank you so much. And I know chat enjoyed having you on, and we'll have to do it again.
Anytime. I really enjoyed talking to you. Thank you.
Yeah. Have a good day, Dimitri.
You too. Bye-bye.
All right. Bye. Well, that was That was enlightening. I needed that. I needed to ask those questions. And I hope that it helped you guys understand a little bit better too how the system works. And Jammers, I agree. I think it's great having him, and he doesn't know the case of Idaho. He doesn't know all of this stuff, but I like that he's not conspiracy theory bound. He's very factual, very common sense approach. Love Dimitri. Love having him on the channel. Love having you guys here. I appreciate you guys coming in. And replayers, let us know your comments in the comment section. So I'm going to go ahead and wrap this up. And we are not done with Delphi. We are going to keep digging into this and talking about all these questions. And we can have Dimitri on again. So if you guys have any questions, we can always address those in another live as well. So thank you so much, you guys. Thank you for your support. And I will see you guys in the next video, whenever that is. See you for sure Friday at 3 p.m. Eastern Standard Time. Friday, we're going to be covering lots of stuff. Lots of stuff. So let's get on out of here. I don't think we have the dance it out on this thing. I don't. We can't dance it out. So we're just going to end abruptly, and it just doesn't feel right. Wait, hold on. Hold on. We might have the music.
Roly-poly, daddy's little fatty. Daddy's gonna be a man someday.
Have a good night.
Roly-poly, daddy's little fatty. Daddy's gonna be a man someday. Roly-poly, daddy's little fatty. Daddy's gonna be a man someday. Roly-poly, daddy's little fatty. Daddy's gonna be a man someday. Roly-poly, daddy's little fatty. Daddy's gonna be a man someday. Roly-poly, daddy's little fatty. Daddy's gonna be a man someday. Roly-poly, daddy's little fatty. Daddy's gonna be a man someday. Roly-poly.
What is going on?
Daddy's gonna be a man someday.
I'm dying. It won't end.
Daddy's gonna be a man someday.
I can't breathe.
Roly-poly,
It won't stop.
It
wouldn't go off live.
Hi Jennifer, hi Jennifer, hi Jennifer, hi Jennifer, hi Jennifer, hi Jennifer, hi Jennifer.
I love you guys. I got it to turn off. Bye.